Last name,
Okay.
what's your first name?
Priscilliano.
Priscilliano Mendoza.
All right, we are on the record in 2022 TR 2328, State of Kansas versus Priscilliano Mendoza. Jared Regier for the state. Defendant appears in person and pro se. I show you've had Darren Patterson before, though. Is that correct?
Could you repeat yourself?
Yes, I show that Darren Patterson has represented you in the past. Is he still representing you?
No.
Your Honor,
Okay. Yes, Mr. Regier.
forgive my interjection, Your Honor, but the state does have a recommendation in this matter based off of the previous journal entry of sentencing.
Go ahead.
Your Honor, this is a case where it does appear that the court proceeded to disposition and sentencing in December of 2020.
Okay.
The journal entry of misdemeanor conviction and sentencing does appear to refer to a date by which the case was to be paid in full or requiring the defendant to appear in court on that same date. Based off of the state's understanding, at least as of March of 2023, there was an outstanding balance in this case. The state does respectfully submit that this matter should be sent to collections.
Yeah.
All right. So December 19th of 2022, the defendant with counsel Darren Patterson, both present via Zoom at separate locations, entered a plea agreement. The defendant pled guilty to counts 1 and 2, was found guilty of same, was sentenced on count 1 to $100 and a 90-day jail sentence with a 6-month non-reporting probation. On count 2, $63. Count 3 was dismissed. Attorney fees were waived. The court costs of $108 were imposed, and he was told to pay the total or appear for a review March 13th of 2023. Looks like he neither paid nor appeared for his review. Therefore, the court could find him in violation, but this is not the hearing we intended to do that, or I would impose Mr. Patterson as his counsel if he qualified again. The financial balance is $271. I think he paid a cash bond. Let me double check that. It looks like he posted a $271 cash bond on May 31st, 2025. And since he paid cash instead of giving that to a bondsman, I would propose as an alternative, Mr. Regier, that rather than sending it to collections, that it be paid from his cash bond and then decide whether or not to proceed with reinstatement of probation or release him. Mr. Mendoza, you don't have an attorney here, but how do you feel about what the court has just said, or do you want to talk to an attorney first?
No, I don't need to talk to one.
You want to proceed on your own behalf?
Yes.
Do you know that I can stop and have you apply for court appointed if you can't afford to hire an attorney?
Yes.
And do you want to hire an attorney or apply for court appointed before we proceed further?
No.
You just want to continue on your own behalf?
Yes.
All right. Is anyone making you waive your right to an attorney?
No.
All right. Then I'll have the record reflect that you're proceeding on your own behalf today, knowing you have the right to an attorney, but not exercising that right. On your own behalf, what do you think of the court's proposal of just paying the $271 out of your cash bond and maybe closing the case, or transferring you to a non-reporting probation?
That sounds good to me.
All right, then, Mr. Regier, how does the state feel about that?
Your Honor, on the issue of probation revocation, it would appear that, one moment, Your Honor.
Mr. Regier, I see you're still on camera. Have you had a chance to research what you wanted to? Are you ready to go?
The state is prepared to proceed, Your Honor.
All right. We are back on the record in 2022 TR 2328, State of Kansas versus Priscilliano Mendoza. All parties as before. Mr. Regier.
Your Honor, this appears to be a case where the court had previously granted the defendant a 6-month non-reporting probationary period. The state is not aware of any warrants show cause or orders extending probation before the court. Therefore, the state does respectfully submit. It would appear the statutory time frame for such a document appears to have elapsed. As to whether or not the cash bond is to be applied in this case, it would appear that the state is not aware of any necessary paperwork being executed to that effect. Therefore, the state does maintain its position, absent a contrary finding by the court, that this matter should be sent to collections.
All right, I am not going to send this to collections because I think it would complicate the defendant's ability to pay. And Mr. Mendoza, if you want that 271 cash bond applied to your balance, you'll need to go to the clerk's office and sign any necessary paperwork. And if anyone else posted that in their name as opposed to yours, such as a father, a brother, a girlfriend, they'll have to come down and sign the release of that to apply it to. But I will authorize that, and I'm going to set this on a Monday with Mr. Patterson in case for further review. Let's do, can we squeeze him in on October 29th at 8 a.m.? Destiny?
Your Honor, the 29th is a Wednesday.
Oh, okay.
And Your Honor,
27th? Yes?
is the court appointing the public defender to this matter? The state understands that previously on the record, the defendant had waived his right to counsel.
He did, you're right. So no, I'm not going to. All right, I'm going to approve Mr. Mendoza's application of bond to pay his case. That will be the order. And when payment is made, I'm going to close the case. Probation completed. Is that what you want me to do, Mr. Mendoza?
Yes. How much do I need to pay?
Well, stop at the clerk's office and they'll tell you the balance. What I'm seeing on the computer system is 271, which is the amount of your bond. So you may be able to just apply your bond money directly if that has not been returned to you, and it doesn't look like it has.
Okay.
So stop by the clerk's office. They'll tell you how to get that paid. And I'm going to order that you pay that right away. And if you don't get it paid, then the notice will go up to Topeka to your license. You'll probably get your license suspended. And driving without a license is a pretty big deal.
Okay. Thank you.
So if you can get that signed over today, that's what I would want to see you do. But let's pull this in 1 week. Let's put this over. What's a week from today, Jen? 8/27?
It would be the 27th, Your Honor.
Let's set this over to 8/27 and make sure that you or whoever signed that bond gets it signed over to the clerk within the next week if you want to get this closed on by the 27th, on or before the 27th. Okay. And in the meantime, until the case is closed, of course, you're welcome. Now pay attention here, 1 more minute. Make sure that until this is closed, you don't violate your probation in any other way. Make sure that not only do you get it paid, but you also don't go out and violate any laws, because that could get your probation revoked. And if you didn't go out and get booked and printed as required, that could be a violation of your probation, but you're on bond, so I know you did get your picture and prints taken. So just don't go out and commit any new violation of the law between now and the time you get this case dismissed.
Okay. Thank you.
You're welcome. You may go, and if you haven't paid, you need to be back here a week from today.
All right. Thank you.
You're welcome. You may go.
That hearing had a little bit of everything. Judge Webster presided over the case of Priscilliano Mendoza, and while it began as a straightforward probation review, it turned into a practical exercise in how courts balance enforcement with fairness. Mendoza, appearing without an attorney, confirmed he wanted to proceed on his own behalf, politely waiving his right to counsel after the judge carefully explained the options. The issue was simple. He'd been sentenced back in December 2022, owed $271 in fines and costs, and by March 2023 had neither paid nor appeared for review. Normally, that could trigger collections or even probation revocation, but Mendoza had posted a $271 cash bond in May 2025, effectively holding the funds in the system. The prosecutor argued that the matter should just go to collections, but Judge Webster wasn't persuaded, pointing out that sending it to collections would complicate payment. Instead, he proposed applying the bond directly to the balance and closing the case. Mendoza agreed readily, respectful, and cooperative throughout, saying, "That sounds good to me." The judge authorized the bond transfer, but reminded Mendoza that if someone else posted it, like a family member, that person would need to sign paperwork at the clerk's office. The judge also set a 1-week review date, August 27th, to make sure the payment paperwork was complete, warning Mendoza that until the case was officially closed, he needed to stay on his best behavior. The overall atmosphere was calm and pragmatic. The prosecutor pressed for procedure, the judge focused on practicality, and the defendant, while soft-spoken and deferential, showed he understood his obligations and wanted the matter resolved. Judge Webster's tone was steady and instructive, carefully balancing accountability with an efficient solution, and Mendoza left with clear instructions and a path to close his case without further complications. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.